Good morning. Good morning.
Good morning.
Good morning.
Good morning.
Okay. Okay, trust all is well. This is our last class and our little review before our midterm. Which date they have you down for midterm next week?
No one said anything to me.
Okay, let me confirm that before the class is over.
Thank you.
What did you find out about our industrial benefits? Anything?
Yes, I did.
Excellent. Let me know.
Okay, the industrial accident is defined as any work-related incident involving injury to one or more persons. Example, slip and falls, equipment or vehicle turnover, being struck by vehicle, equipment, etc.
Okay.
Or, yeah, any
So-
work-related incident.
Okay, so if I slip down and fall on the job, that's industrial. Or what else? If I get,
Hurt by equipment or vehicle turnover or hit by any injury relating to
what?
the equipment or vehicle or work, anything that happens that injures you during work.
So if I'm in a chair and I fall out of the chairs, would they consider that or you
They
didn't see
would,
that?
they would investigate the actual incident first. Whatever the incident is, they will investigate. And once they've determined it to be an industrial accident, then they will pay based on that, but they will do the investigation first.
Okay. Anyone else did any research on it?
I actually had a question on that I had posed to the labor board at the start of the pandemic when persons were being encouraged to work from home. And I was wondering if the home environment, because the employer had asked the employee to work from home, if that constituted, while they're in the course of their duty at home, an injury there could be classified as industrial.
I don't know if that could happen because then they don't define whether you were actually that's the home. But I think microphone, it's giving us feedback. Yeah, I don't know that could play into their industrial accident, mainly because you're at home. And then there's no separation there, right? We can't separate if you're actually in the course of employment or at home.
But let's use the same example. You are working from home, you're sitting in a chair, even if it's a chair the company provided so that you could work from home, and you fall out of that chair, it slips away and you end up hitting the ground and injuring yourself.
But I don't know that that's still, you could put that in the work setting because that's not actually a place of work. It is defined first as at home. So now if you are packaging items, suppose you were packaging equipment for the workplace, then you could say that you were in the course of an employment, but your chair at home and what you may be doing, and it is something else, you see?
Yeah, but you could argue
But
that if you
actually,
could prove that
the
you were
work
actually working.
for like, yeah, but then again, it's not in a work setting. So suppose your home isn't equipped for that chair, then is the national insurance responsible for that?
That was my
You
question,
see?
was what was the responsibility of the employer when we tell people work from home? That was my, that was
Right,
actually
so
the gist
now
of my
that's
question.
where you'll have to see, even if the insurance even recognizes you working from home, because I think they need to adjust that with their insurers as well.
Yeah.
You see, because then people say, well, no, man, that person is working from home. We don't know that it's properly fitted. It has the health and safety standards. All of these things have to be considered when you're telling persons to work from home, because you're going to have those challenges, in particular with insurance companies. You know, they usually find a loophole.
Yep.
And so that can be at a disadvantage for the employee who depends on the insurance of their employer to be able to claim if something actually happens during the course of them carrying out their work in a different setting that is away from the workplace. Because I think that's a part of the insurance clause. They cover you while you are on the work premises or during the course of your employment. But I don't know that it would be in the setting of a home environment unless that is adjusted within their insurance clause, because that's important.
But you know, you could also argue, because if you're in a company vehicle, not at the place of employment, but in a company vehicle, you can argue
that's
that
a difference.
it could be covered.
Right, but that's a difference because you're actually covered within the vehicle. Wherever the vehicle may be, the coverage is there for the vehicle and while you're doing the work in that vehicle, but not where you're not in a setting that's covered. Yeah. Now, even in the course
how our laws need to be adjusted based on the new world of work that exists now.
Right, so people have to take that into account now and look at that differently. I think even in the course of your employment, you know, even when you're driving your vehicle, you have provisions in your insurance clause which covers you, and if you're outside of what you're, so they don't cover you if you were driving on a racetrack.
Right.
So, you know, we have, they have the tracks over here. So suppose you were out there on a Sunday and you were, say you were, hold on one second. You were to get in an accident out there, the insurers may be able to come out of that because you were not using it for personal, for the purpose of the insurance, for your personal use. You were using it in a different setting. So I know they have that, they have clauses like that to cover themselves just in case you're acting outside of what the insurance covers.
Right.
So likewise, I'm thinking that will be the same thing with you working from home. There's always a way around, the insurance office will have a technicality they can work with. So many times people are insured and they were not aware of certain things that were conditions that would have triggered the insurers to look into it a bit further, and they may have died. Their family goes back to get the insurance proceeds, and they said, oh no, based on this autopsy, he had some heart issues earlier in life, and he didn't disclose that to us, so the policy is no longer valid. So I mean, these are things that usually happens. So you have to look at all those things.
Okay. Thank you.
Like
So
you
any
said, Ms.
other-
Dorset,
Uh-huh.
an insurance policy is a contract between the person and the insurer. So you said it have to be legal, it have to be fair and all these things. So if you lie on an insurance application,
But see, sometimes it's not lying, you know, it's just that you didn't see that it was related. Like sometimes they may say, have you ever had heart conditions? A heart issue or something or the other, and you may have like years and years ago, you went on a run, and then when you had a issue, just a trivial issue, and they may have diagnosed you to say, oh, it seemed like your heart rate was irregular, but nothing ever came out of it. And so you didn't find that to be of any moment because it was just in passing, more or less.
right?
But that may have been of record somewhere. And now you go to insurance, and that happened almost 20 years ago, and you're filling out the insurance in good faith without trying to avoid anything. And you didn't see that to be an issue. Now, when you die, they said, oh no, he's died now 40 years later. 20 years prior to him being insured, he didn't disclose that he had some diagnosis, that he had an irregular heartbeat. And we don't know that this contributed. And based on him not telling us that, this voids the insurance. So sometimes it is actually not intentional, and it may be trivial, and it really didn't affect the outcome of the person dying, but the insurers use that to get out of paying the insurance. Because of course they have that where you didn't disclose certain things. Now, any other thing we had on industrial accident, or that was it? We found that everybody, everybody, only one person, two persons, anybody else?
The only thing I told
No.
to elaborate,
Okay, I think Kendra, you still having a little static with your mic. No one else? Toran, Palacios, Jamia, Marsha. Stuart, you could type us something. Zero. Who's Zero, by the way? Let me take the register. Okay. Let's do our register. Give me the names.
Shalon Mitchell,
Hellacious,
What's the first initial Palacios, Laurie?
Tadashi T.
T Palacios. Okay, go ahead.
C. Linden,
What's the first initial McDonald? C McDonald. Okay.
C. Yes, ma'am.
Yeah, okay.
Nikita Isaacs,
And Isaacs, okay.
C. Zervos.
I missed that one. Who that was?
C. Catherine Zervos.
Okay, Caesar. Okay, good. Anyone else?
Teron Fortune.
Okay. I have 6 people so far.
J. Joseph,
M. Lightborn and what's the Joseph?
Shamia,
Okay, good. George. Now, Kendra is, just put your K, what is Kendra? K what? What's the last name? Kendra Martin. Okay, I got you, Martin. Who else I have? Bridget. Okay, so B. Smith, I have B. Smith.
you have me, Ms. Darcy?
Yes, I have C. Linden.
Thank you.
Let me make sure I have everyone. So I have 12 now. Oh,
Sherlyn Hunt,
yes, and I have you now. I have 13. I have everybody now. 1, 2, 3, 4, 5, 6. Who's the NHI? Who is that? You could type. I have you.
that's Nikita Isaacs.
Oh, okay. So that's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 12. Okay, I have everyone. Thank you. Okay, so nothing else on industrial, that's it?
If
No other-
nobody else did, I'll just say what else I found out.
Thank you. We may have this
they-
on exam and nobody check on it. Suppose we have this on exam.
Okay, they said the incident must be first reported to the employer
Mhm.
and that there has to be a doctor's report as well.
Okay,
And the person who is injured makes the claim to NIB.
okay,
And like I said earlier, they have an investigation and the claim is paid depending on the outcome of the investigation.
any difference in the payment?
She didn't tell me, but I
Okay,
think someone was saying it was around $400+, somewhere around there.
right, so I think it's a little higher than the regular sick pay.
Yes, and it takes approximately 3 weeks for all of this to take place.
What about the employer? Anything the employer has to do?
The employer has to submit their report as well.
Okay, so it has to be done by the employer as well.
Right, the report from the employer, the doctor, and then the person who was injured makes the claim.
So suppose you have an exam question that asks you what are the steps if there's an industrial accident at work. Everybody can answer.
Thanks to Mr. Linden, we can.
So we want to make sure that you know about the industrial benefits and accident at work. So you see, you get little tidbits. I give you some tidbits all through the book, and I hope we were following those little tidbits. You all remember who's the president of the Court of Appeal?
so Michael Bonnet,
Okay, what about of the Industrial Tribunal?
is it Indira?
Somebody Cooper, yes.
Of the industrial tribunal, what's the name?
I think Dorset Cooper, Indira Dorset Cooper.
The president now, I
Indira.
want,
Indira Demerit Francis.
The Mayor
Right.
Francis, sorry.
yeah. And what about, sources of law?
Constitution,
Common law. Legislation.
Mhm.
English common law.
Mhm.
Equity.
Even case law.
Mhm. What would we have that under? The primary sources of law?
Primary and subsidiary.
Uh-huh.
Also custom.
Uh-huh.
Equity.
Yes. So how many we have in total?
6.
Yes. Okay, so last week, we went over the employer-employee contract, the relationship, and we remember the types of employment status. What are they? How many are there?
3.
And what are they?
Training and apprenticeship.
Mm-hmm.
Um,
Now we talking about the employment status now.
Employee, agency worker,
Contract.
and self-employed.
Right. And what did we find out about the employer? Who is the employer?
the person who hires someone to work for them, contracts another person to work for them.
Okay, and give me 3 duties of an employer to the employee.
Duty to pay the wages and salary under the terms of contract.
You have to type for us. Give me 3 duties.
A duty to
Na-
pay the
Pay
employee.
national
pay the
insurance,
Uh-huh,
Pay slip.
uh-huh,
no discrimination,
okay,
Treat the employees fairly.
excellent.
Ensure
And what
the health,
about the
safety, and
rights? What
welfare.
are some of the rights of an employee?
A right to be treated fairly and equitably.
So you see how this would be helpful if this was on an exam. If someone asks you what the duties are, the rights will follow it. You just will,
Yes.
you see? So what is another right?
be informed,
Pay.
Say it again.
Time off with pay for
Yeah,
duties and union official duties.
okay. I know you all said they have a duty to give you an itemized pay slip. So that means I have a
Right to it.
right. Yes. So you see, that would be helpful if you had that in an exam that you could play on both sides. Yes?
yes.
Now, the tortious relationship between give me some duties of the employee to the employer though, before we move on to their tortious duty.
Honest and faithful service.
Mm-hmm.
Duty to not damage, deface, or misuse employer's property.
Okay,
Duty not to make a secret profit from his employment.
excellent.
Not to damage or deface the property,
Okay, we get that one. Any other one?
A duty to perform your work competently.
Yes. So should I go there and say I can I can use this butcher machine and I'm not able to use it, what am I doing? Two things fall from that, eh?
Yes,
What that means, I wasn't
It-
honest,
right. And you could cause injury or financial loss to the employer.
right? And I can't competently perform my work, eh?
Yes, no
This
one to
happens
stay
in
work.
white collar too, eh? You inflate your resume and you go there saying you can do certain things and you really don't know anything about the job. But you have papers to get you in the door.
Yes,
So what
that's
about
not-
the tortious relationship? What we call that? What is usually comes out of the tortious, what's the big liability?
Vicarious.
Yes, and what
Vicarious
that
liability.
comes from, what's the ancillary doctrine of respondent superior? What does that mean?
It's where one person is responsible to another person, a third party, for the acts of someone under his employment, care, power, or control.
So that's vicarious liability, but what does the doctrine of respondent superior tell us? What does that mean?
Let the person higher up answer.
Excellent. Make a note of that, please. So by we saying let the person higher up answer, how does that play out in the employer-employee relationship? Who's the person higher up?
The
The
employer.
boss.
Lawyer.
Okay, so if somebody accidentally knocks down a pedestrian while driving the employer's car, who's responsible?
The employer.
Employer.
What if they were speeding?
Still the
The
employer.
employer will
employer.
be responsible.
But what is the catch on that one?
He was speeding.
Right, and so what happens there?
Who's in violation of his, or in breach of his contract with the employer to act responsibly.
So what we gonna get out of that? What we say? There'll be some, what?
Some liability on the employee side as well.
So then we have joint liability there, eh?
Yes,
So if the employee is outside of the scope of his employment, he's off. But he's driving the company vehicle, is the employer still responsible?
yes,
Yes.
Yes.
So this is outside of work hours now. He's still responsible?
yes, the employer's vehicle.
He's in the employer's vehicle. Suppose he stole the vehicle, is the employer still responsible?
Yes,
I would think so.
they're
I would think-
responsible for their vehicle, securing it.
Still their property.
So they still, so the insurance will pay? But the insurance pays if you steal a vehicle.
Yeah, because you're
think-
still an employee.
Right, but if I am, so what you're saying is if I steal someone's vehicle and I mash up someone else's car, the insurance is responsible?
Well, I guess it covers the insurer,
It would cover,
the insured.
I guess,
Yeah.
based on the insurance contract.
Right, so if someone steals a vehicle and they don't own that vehicle, what happens then? Is the insurance responsible?
No,
Okay, so the employee now steals the company's vehicle. He's partying and everything else in between.
the employer
And
wouldn't be
it's 10
responsible
o'clock in the
because
night.
it was not an authorized, it was not authorized, so I don't think the employer would be responsible.
So what they say? When we go on page 65,
It says the employee must be acting within the scope of his employment for the employer to be liable to a third party for the employee's
Right.
actions.
because any act done outside the scope of his employment will make the
Will
employee,
make the employee directly liable.
okay. So if I pick up somebody in the company's vehicle, while on company time in business, what that is?
The employer is
Who's responsible?
the employer.
Employee. Because what that is,
He's
what I have
he's
on there,
acting
no,
outside of the scope. He's acting
That's
outside of the
right.
scope.
I have
But
no
if-
riders, right? And I have no
Yeah.
riders on my car.
Yes, yeah.
Right.
So if
he's
the,
outside of the scope.
if the
Mhm.
employee's boss said, go and pick up someone,
That's different.
then, okay, yes.
But if you pick up someone, unauthorized passenger
On your own.
with no,
Then,
you
yes.
pick them up, that's unauthorized. While
Yes, on your
working.
own.
Yes. Of your own volition.
Right, on your own, yes.
Yes. So what that means,
You're
You're
responsible.
responsible.
right? So when they die in that vehicle or something happens terrible, what happens?
The employee is responsible.
Excellent. Okay, I think we have vicarious liability covered, so if we see that on exam, we could mash that up. Yes?
Yes.
Yeah.
Good. All right, so let's move on to this chapter, module 5, which is employee recruitment, selection, and performance. This is where we talk about those references,
Yes.
and protection and all that stuff of your data. After completing this unit, we should be able to gain knowledge on the law and best practices in employee recruitment, selection, and performance, develop an awareness of the factors to be considered in recruitment and selection, obtain information on the best strategies for employment, recruitment, and hiring, gain an understanding of the components of an effective appraisal system, and develop an awareness of data protection laws in relation to employee information and privacy rights. Who will help us this morning with reading, recruitment and selection?
I'll go first.
Thank you.
Recruitment and selection. Recruitment is defined as the practice of analyzing a job, outlining the characteristics, competencies, and capabilities that an organization seeks in a potential candidate, attracting candidates to apply to the organization based on various advertisements and other means, and offering certain terms and conditions of employment to a chosen potential employee. Selection is defined as the assessment of candidates in order to choose the most suitable candidate for the position offered. Selection is a part of the overall recruitment process. Recruitment process. The recruitment process involves the following steps. Development of a manpower plan, a plan which is a subplan of the overall corporate strategy, which indicates the areas in the organization which may a shortage of people and the number of people to be recruited in order to meet the employment needs of the organization. The manpower plan may come about as a result of organizational change, retirement, restructuring, career progression, employee turnover, or management development. External factors such new legislation, government policies, demographic changes, and technological developments may also influence the impact the manpower plan. The recruitment program is derived from the manpower plan, and an action plan is developed outlining the number and type of staff to be recruited, trained, and developed. The recruitment program may be governed by the organization's overall human resource and organizational strategy regarding the specific time period and method for recruitment, both internally and externally. If performed effectively, the manpower plan will indicate to the organization the number of people they wish to recruit and at which level for various jobs within the organization.
Okay,
Two.
so before we go on, because we have some steps to follow in the process. So we have recruitment is defined as the practice of analyzing a job. We will outline what are the characteristics, competencies, capabilities that an organization seeks in a potential candidate. So before you engage to hire someone, you will look at what is needed within the organization first. So more or less, you're gonna procure an individual to work for you. but you need to see what you need from that person. So you would have to say, I need them to do this job. So basically, based on this job, we need this person to be able, so if we need a typist, what do we need? What characteristics we looking for in a typist? Or
Competency on
let's use
keyboard.
something that you're familiar with. What areas
speed.
y'all in banking?
Speed,
Okay, speed. Uh-huh,
margin, error margin,
Mhm.
okay.
Proficiency in computer.
Okay, so what are these? What you talking about? So you talking about competencies and capabilities now, right?
Yes.
Yes.
What about the characteristic of the person?
people
Okay, good
skills,
communication skills, yes. So they should be able to, they should have their grammar down then, eh?
Mhm.
yes,
They need to be able to read.
Certainly,
time
So we-
management,
excellent. So first of all, and what we'll say first, we have a lot of work coming in. These executives are in a lot of meetings, and so they don't really have time to do what? Prepare their work for what? Dissemination, right? So now what I have to do, I need somebody to help them, and so that's how we came about analyzing this job, right?
yes,
So now we've analyzed the job, we realize what the characteristics are, and then what we'll do in order to get them now to come in, what we have to do, what we're gonna do next.
advertise,
Write a job description.
So
Oh,
we
yeah.
need to put a description of what are we gonna put in this description? What we just, what?
The
Outline.
competencies and
That's what we're gonna put in there. And then how we gonna get that out to the public?
gonna
Advertise.
advertise,
So then that's a part of our recruitment process. We're gonna now see about how we're gonna advertise it, what is the most effective means that we'll get this advertised, and then what are we gonna look at as well in order to give this job out. And we've already identified what competencies, now we're gonna look at what?
Qualifications.
We have the qualifications, so what is next? We know we're gonna advertise, where we're gonna advertise. What else?
compensation,
What we gonna need?
compensation and offer or
Yes,
something,
consideration now. So we need to know, right, what is the scale, salary scale, what the conditions and terms will be, when we
The
need them to
benefits.
work, if it's Monday to Friday, what's the hours, all of that stuff, eh?
benefits.
So
and all that.
now, once we've done that, what we do next? We are gonna do what? We finished recruitment, so next is?
selection.
Yes, and so selection will be based on who we determine to be. We have to do
Most
what?
suitable
So how will we do that? By doing what?
interviews,
Interview.
And what we'll call that process?
the recruitment,
No, we now doing what?
Interview process.
selection, sorry,
Interviewing.
Yes, we selecting, but what we'll call the overall, that's it's an A word. We are assessing. Yes, Smith said it, assessment. So we're gonna assess them as a part of our recruitment process, and that's how we'll select the candidate. So the process involves the steps. The first step is the development of a manpower plan. So what do we do with the development of a manpower plan? We are now gonna set up our organization to see what personnel is needed, what areas we need them in. So we'll have set out a what? More or less an organizational planning of what potential candidates we will need. Before we go out, we don't just pick up candidates willy-nilly. We usually have a plan of how many persons we'll need. If we just a startup company, we'll say, well, basically we're gonna need 2 executives working here. We're gonna need 4 tellers. We're gonna need this. So, but right now, our plan is to hire 2 of those tellers. One of those, we need at least 2 or 3 janitors, but we're only gonna hire 1 now. So we're gonna develop this manpower plan, okay? And it'll show us what will happen, how, what all will be included in there. How we're gonna restructure, if anything, retiring persons, progression of employees, their careers, the turnover of the employee, policies that, government policies that may affect us, our manpower, demographic changes, that's the work if, we're no longer in this jurisdiction as, the work isn't generating this much, so we may decide, okay, we're gonna have to get rid of some of these jobs. Technological developments, how does that affect the workplace now? Would we
Well-
find that it is, how is that affecting the workplace?
People are being laid off.
Yes, because who they sitting in there? ATM sitting on it in the teller spot.
Yeah,
Correct, yes.
automated.
Right, but the tellers were so comfortable to treat you badly now that ATM take over.
They're doing it even worse now.
Oh, boy. And you would think they would say, well, Lord, these ATMs taking us over, we gotta change our ways. They still don't do no better.
No, it's worse.
So these developments now, all of these affect your manpower plan, and this is how you determine, this is how you develop your plan in the recruitment process. So this is one of the first steps we will deal with in setting up our manpower plan, because all of these factors will be now considered in there, eh?
Yes.
Okay, any questions? So the program is now derived from that manpower plan, and then we action our plan based on how we're going to recruit, yes?
Yes.
So this will now help us to determine how many persons we're going to recruit, which levels we're going to recruit them. And this will also tell us if we need to get rid of some people, eh?
Yes, it will.
Excellent. Okay, so we understand where we are now. You'll see the progress would be going through. Right?
Yes.
Good stuff. Next, then. Any questions? Or we good? Okay, let's go ahead. Thanks.
Number 2, a job analysis is conducted where the specific tasks that the potential employee will be required to perform in a particular job are examined. These tasks are recorded in a job description, job specification. The job analysis may incorporate a structured approach, which takes into consideration the following aspects. A, objectives, aims and values of the job to the organization. B, responsibilities to whom and for what. C, types of decisions. Are there authorizations, ratifications, or verifications? D, attributes, experience, skill, personal qualities. E, environment, the culture, nature of the environment.
Okay, so the job analysis is actually conducted from specific tasks that the employee will be required to perform. Now, the job analysis and the job description seems similar, but the analysis takes place before you can write your job description. So the analysis will tell us what is the objective of the position, the responsibilities, the types of decisions the person can make, their attributes, and the environment where they'll be working. Okay. So now we have to make sure we differentiate the job analysis from the job description. We should know the definition between the two of them. Okay.
Yes.
We get that? What I say?
You're
What we
saying
should know.
basically that the analysis is not the same thing as a job description.
So that's important to know. Okay.
Yes.
Make a note, please. Okay, go ahead.
3, a job description is prepared from the job analysis, which outlines the activities, tasks, and responsibilities of a specific job. Simply, it is a written statement of job content. The job description is supplemented by the job specification, which stipulates the methods necessary skills, and knowledge required to perform the job. The job specification goes further to describe the nature and purpose of the job, responsibilities, where the position is located, and to whom the individual reports and is responsible. It is important that all employees have a job description for good performance management and clarity on their roles and responsibilities within the organization.
So we know now the job description. So the job analysis is conducted where the specific tasks that the potential employee will be required to perform in a particular job are examined. The job description is prepared from the job analysis, which outlines the activities, tasks, and responsibility of a specific job. We see the difference in the definition, right?
Yeah.
So we get the job description based on the job analysis. Okay, so it is a written statement of the job content. Yes. And it describes the nature and purpose of the job, responsibilities, where the position is located, to whom the individual reports and is responsible. And it's important that every employee has a job description in order for good performance management and clarity on their roles within the organization. Because, you know, a lot of times persons want to refer to their job description when you ask them to make them a cup of tea. I don't remember that being in my job description. Let me look over this to see. But then we have this catch-all at the end, usually, eh? What is that
Yes.
catch-all? Would they put it there?
Any other changes assigned?
Now, do you think that's fair that they can put that in there?
But it has to be related to your job, the job description though, not just outside of it.
Yeah, but they don't say that. It's
No.
usually big, eh? It say
Yes,
from
it
time
is.
to time as management may direct.
Right,
So you
Well,
may
and-
send me a whole different area code, eh?
right.
And can I now dispute that?
No,
Because I agree to that, eh?
yes.
So if I
And
see
it's
that
on
on
every
my
job
thing,
description.
I would ask them to define that a bit more because I don't want to be open like that, eh?
Mm-hmm.
Yes, because then you may tell me sweep the floor and I can't say anything because I didn't specify. Because management directed me to do that. Now, what do we have as a blowback to that?
The union.
No, we have some things what we can talk about. Remember we talked about this?
Your contract, eh?
We say the duty. What we say about this duty? Duties of an employee to an employer.
Right.
We have
Oh.
obey. We have a duty to obey all reasonable,
Yes.
lawful orders and demands by the employee.
Yes,
Yes.
yes.
And we have a right to be
Treated fairly,
and equitably.
equitably.
So we'll throw these back at them, right? When they
Yes.
come with this big clause, eh?
Ooh.
When I asked about it, I was told it cannot be without the scope of what you do already in your job description. That's what I was told when I asked, when I first joined the corporation and I saw that.
Right, so now that's subjective, eh, to who telling you that, eh?
I agree.
Because somebody may interpret that to be something else when you get before them. Yes,
Yep.
so we're gonna need to know what your duties are to me and what my rights are as an employee. Yes,
Yes,
Right. I think what is requested also has to be within your competencies as well.
right, so am I competent? And then when you send me over there and I was incompetent, what happens?
An
we have a
accident can happen.
vicarious liability.
Yes, yes. So you see how you're doing so well? Oh, no, this book back in front. All right. So let's go on to the personnel specification now.
All right, a personnel specification is also developed from the job analysis once the job description has been completed. The personnel specification indicates the type of person who is likely to perform optimally in the position. It may include the following information depending upon which format is used. A, abilities. B, qualifications. C, motivation. D, influence, leadership, impact on people. E, adjustment. The job description and personnel specification may also assist the potential employee to assess whether he has the requisite skills and attributes for the particular position. Potential applicants may be able to be screened initially and appropriately shortlisted based upon the information provided in both the job description and personnel specification.
So the personnel specification is also developed from the job analysis, eh? Once the job description has been completed, and it indicates the type of person who is likely to perform optimally in this position. So we should see so this is also depend on the format which is used, and it's based on your abilities, the qualifications, the motivation, your influence, leadership or impact on persons, and adjustment to the work environment. So the job description and this personnel specification will assist potential employees to assess whether they have the requisite skills and attributes for the potential position. So what I may put in there that will cause you to know this not the job for you. Ability to supervise persons, or what else I can put about leadership? If you're supposed to be a leader,
Previous experience.
ability to do what? Work on your own, unsupervised, all that stuff.
Make
Self-style.
decisions, make
Yeah.
decisions.
So these things we're gonna put in there. So these abilities we're gonna put in there to ensure that you know this is not the job for you, or this is the job for you. Okay,
Okay.
next, the organization. Be there.
5, the organization may then determine the job vacancy and necessary qualities of the potential employee after successfully completing the job analysis, description, and job and personnel specifications. The organization then attracts people to apply for the vacant position, often incorporating headhunting for more senior positions and or specialist job search agencies to recruit individuals. The potential application completes the employment application and sends his resume to the designated contact within the organization or hiring agency.
Sorry, that's supposed to be applicant there, because we have some spelling errors and typographical errors, that is.
Right, okay, all right. The applicants are vetted through a process which may be specifically outlined, and the ideal candidates are shortlisted. 8, shortlisted candidates are notified. 9, interviews are conducted with shortlisted candidates. 10, review of interview results and an examination of the potential employees' qualifications, skills, and attributes are conducted after the interview.
Okay, so then the organization determines the job vacancies and the qualities of the employee after they've completed the analysis, description, and the personnel requirements. And then we now do what? What we call that process now, what we gonna do?
Advertise.
Yes, we are advertising, or we get some persons to look for some, they go out looking for specialized specialists in these areas for us. Once we've advertised, the response now is that the applicant completes the application, the employment, and sends the resume to the designated person within the organization. The applicants are then vetted and we ideally shortlist the candidates that are suited towards what we have there. What are we gonna be able to shortlist them from? How will we short-
Analysis.
Their resume.
Oh, right, but what their resume is being shortlisted against what?
The job description. huh?
Yes.
And the
so what-
personnel requirements.
Right, so we looking at all of these things in order to shortlist you, so we'll see, okay, you are ideal, you this, so we take out of the 15 candidates, we were able to identify 6 persons and they're now shortlisted, and those persons are notified to come in for an interview. So based on me interviewing you, we review the interview results and examinations, and then we determine who's the selected or preferred candidate based on the interviews and all of the attributes that we were looking for, yes?
Yes.
So that's our what? That's the whole of our what?
Selection process.
Selection
Yes.
process, and that's the recruitment process, right? That's the end of the recruitment process there.
Right.
Yeah. Okay, so next, law relating to recruitment. Are you gonna continue or we wanna?
I mean, if someone else wants to, it doesn't matter.
Someone else can help us? Or-
I can go.
Thank you.
Law relating to the recruitment process. While there is no specific legal obligation on employers to prepare job descriptions, it is highly advisable to do so as a matter of good practice. Additionally, a clear job description, which is used consistently throughout the recruitment process, helps assist in eliminating discrimination or potential discrimination or bias in the recruitment process. Employers must take care to ensure that the specific content of the job description is relevant and appropriate to the job, and any specific requirements are necessary to perform the job. Where employers define criteria that are not actually relevant or necessary, and they may subsequently rely on those criteria in accepting or rejecting job applicants, this may result in a potential risk of discrimination, as the criteria may not be justified. Example, full-time work requirements, etc. While Bahamian law does not imposing minimum or maximum age limits for applicants, except stipulating the age of retirement for men and women for national insurance and other purposes, employers must ensure that any age limits that they do set for a specific position can be objectively justified. In reality, and advisedly, the use of age limits in the application process will be justified only in exceptional cases. For example, Wolf versus Stad Frankfurt and Maine, 2010. Preach and Ors versus Destouche Lufthansa, AG 2011. With regard to personnel specifications, there is no specific legal requirements to do so. However, it is highly recommended. Similar to job descriptions, a clear personnel specification that is applied fairly and objectively throughout the recruitment process may help to eliminate discrimination. It is important that the personnel specification contain criteria that are real and necessary requirements for vacant position and for the potential employee to perform the specific role in the organization. It's good practice for the employer to use detailed and clear terms in the personnel specification in order to appropriately and reasonably justify their necessity and minimize the risk of discrimination in the recruitment process. For example, requiring a person to be physically fit. It is a good practice to outline the specific tasks that the potential employee may be required to perform instead of making a statement requiring physical fitness. In some instances, the requirement of a particular type or level of qualification has led to claims of age discrimination in the UK, who may have felt that they are not able to obtain the required qualification. except where Bahamian immigration laws require employers to do so for the issuance of foreign work permits. Generally, the law does not require employers to advertise a job or to use any particular method of job advertisement. However, employers are advised to take an objective and an unbiased approach to recruitment advertisements to avoid issues of potential discrimination in their recruitment practices. Recruitment advertisements should be objective and clear in their content and enable potential employees to obtain the appropriate information regarding the vacant position. They should also provide real and necessary requirements for the job and not exclude persons from applying based on conditions of race, color, gender, sexual orientation, health, disability, or religion. The content of the advertisement should be customized to the requirements of the particular vacant position being advertised. Regular reviews of advertisements should be conducted to ensure that the content is written specifically for the position advertised. There is no legal requirement on the information that should compromise a job advertisement. However, it should contain neutral, unambiguous words that do not discriminate against a particular group of people, include the relevant experience, skills, and academic requirements for the job, and outline any pay or benefits, as well as an explanation on the application process and the closing date for applications. Likewise, the images used in job advertisements must be carefully selected and should not in any way discriminate or marginalize a particular group of people in their depiction of the work to be performed or otherwise. Employers may use a variety of methods to conduct recruitment, advertising, and it should be noted that there is no specific legal requirement for employers to advertise jobs internally within the organization or externally. Therefore, employers may use any communication methods, example, social media, print media, intranet, job agency, etc., that meet their recruitment needs and employment goals. Continue.
Yes, please.
Employers should be particularly careful not to use personal information found in personal profiles on social media sites against an applicant in a discriminatory manner when recruiting employees. Employers should ensure that their recruitment policies regarding social media recruitment strategies are consistent with anti-discrimination best practices. It should be noted that while the use of hiring employment agencies and headhunters is common practice in the recruitment of senior management and executive positions, employers must properly advise the agency of their recruitment policies, including any equal opportunity and other relevant policies, and ensure that such agencies recruit in a non-discriminatory manner, or they may be liable for the discriminatory acts of the recruitment agency under the law of agency for any recruitment decisions made on their behalf. Additionally, the employment agency should be provided with the job description and personnel specification for the position advertised. Generally, individuals do not have a statutory right to take legal action against a potential employer on the basis of discrimination with regard to their advertisements. However, an individual may use a recruitment advertisement as evidence to demonstrate an employer's discriminatory actions, or that they may have been prevented from applying for the position due to this discriminatory advertisement. Individuals must not only provide evidence of the discriminatory advertisement, but also show evidence that they may have been unfairly treated or disadvantaged as a result of the advertisement. In other words, it is a two-pronged test based in proving discrimination in recruitment advertising against a potential employer. Potential litigants must also have intended to apply for the job in order to commence a successful action based on discrimination in this regard. For example, Berry versus Recruitment Revolution and others, 2010.
Okay, so the law relating to the recruitment process says there's no specific legal obligation on employers to prepare job descriptions, but it is highly advisable to do so as a matter of good practice. Because what it does, it provides you with a clear job description that is used consistently throughout this recruitment process. And it eliminates discrimination or potential bias in the recruitment process. Now, they must make sure that there's nothing in there that would be irrelevant. So it shouldn't the biases shouldn't be you imposing age limits or you putting whether you have to work full time. Now they can be they can use alternative descriptions that won't cause them to look as if they are being biased or prejudiced against someone. What I'll put if I don't want to put an age limit, what can I put instead?
Entry level,
So that means I want to what?
a younger person.
A younger person.
Now, if I don't want none of them young people in my door, what I'll put?
Experienced.
What I gonna put for experience?
Mature.
No,
I've seen that.
what else you can put in there?
Or you can
Yeah,
say
it
they
can-
need to have a certain number of years experience.
Yeah, so I don't want nobody 25 or younger, so what I'll put?
30 years
At least-
experience.
And
At least-
15 years.
So at least 10
15.
years, at least 10
10
years experience working in this, in a position.
Right.
So
In a
that
simple
wipes
position,
them
yeah.
out, eh?
Yes.
Right there, so that's what I'll do there. What else I can do now if I don't want if I want a full-time worker? What can I put in there? The position requires what?
40 hours per week.
Yes.
9 to 5, Monday to Friday or something like that.
Yeah, so the position requires you to work. The position is from Monday to Friday. And the requirement is at least 40 hours of work within the hours of 9 to 5.
9 to 5.
Now,
Yes.
right, so what else we see that they use that's colorful?
Must be able to speak Portuguese.
Now, now tell me how that works out in the Bahamas. What we gonna say?
They don't want Bahamian.
Yeah. So what I'm gonna say, what we gonna say about that? Well, how does that affect us? We know that's the immigration to do there. Eh?
Yes.
They just advertising for immigration purposes. But
Right.
Bahamians don't say anything, so what's the harm, eh? Nobody really worries about it. They don't.
No, but like you said, you have to prove this. So why would I go and complain about it when I can't speak Portuguese anyway?
Right,
But
so
the-
what am I going to do based on that?
I would ask, what's the relevance of speaking Portuguese to the job? I mean, if you're doing clerical work in English, to put in a qualifier that you have to speak Portuguese, I would query, how does that complement the job? Or where is it
So-
required within the job?
So what am I going to say? That I want to take legal action?
Based on,
What?
Language discrimination.
So discrimination, so based on discrimination with regard to the advertisement. But
Yeah.
what I have to do, there's a two-pronged test. How can I take legal action? What's the first step?
you have to prove the discrimination
So I have to prove it with the advertisement,
with the
right?
with the advertisement. Yes.
And how will I show, how does that affect me? What am I going to show?
That I intended to apply.
For the job, right?
Yes.
So I am now being unfairly treated or disadvantaged as a result. So that's a
That I
two-pronged
don't speak
test.
this language. Yeah.
So we should know that two-pronged test, eh?
Yes.
Good stuff. What else? So now I need you to be able to run up and down stairs. I need a messenger. So I don't want no old fogey come here who I have to help out. What I'm gonna say. Person will be required to do what?
Physically fit.
No, I can't put that there, remember? What I'm gonna-
Oh,
So how am I gonna be colorful in this.
Deliver packages or something, deliver boxes
So-
or
So persons are required to do what? Because you have to
Lift.
lift.
Some
lift
Uh-huh.
physical labor.
items. Lift
Physical labor.
items, yes.
So you're required to lift
Up
any
to a
items or
particular
some-
weight.
Right, so we have to lift items that are at least,
At least 50 pounds.
right, must be able to lift items that are at least 50 pounds. What else we need to know? Ability to what?
Stand for long hours.
Yes, all of these little things. What else do you put in there?
I've seen one that said be able to drive a forklift.
Okay, so that's it. So we put all these little things in there, so we have to make sure we put. So in order for you to avoid being sued for discriminatory advertising, you just, what you do, you fix up your language, eh?
Yes.
So you must have eyesight, excellent eyesight, okay?
Mhm.
What that eliminates.
People who are visually
People who-
impaired applying.
Yeah.
Or older adults.
Mhm. So we're gonna use all of these things, but we have to make sure that we're clear. And what are we gonna do when we may have foreigners who wanna apply? What we gonna say?
Must be Bahamian.
No, we can't, we don't wanna say that. What we gonna say?
Preference
I must
given.
be able to speak English, no way.
No,
Must be able to work in the Bahamas.
yes, so we
Yeah.
wanna say you must be able to
Have
work
the
in the
right
bank.
to, right to work.
Yes,
Right to work, yes.
uh-huh.
For my
So
job,
what
only
that
for my
means,
job
I am
in
not
offense
gonna
form.
apply to immigration for you, eh?
Yeah.
Yeah. So you see, you have to know just to fix your language, just to suit without you being discriminatory, right?
Yes.
And
So
government
we know
gotta
the
take it.
2-pound test, if I want to, we know the 2-pound test, eh?
Yeah.
And where that 2-pound test come out, which case?
And Berry versus Recruitment Revelation and others, 2010.
Excellent, okay. So we
Ms.
know.
Dorset, Tehran was trying to say something. I want to hear what
Sorry,
Tehran was saying.
Tehran. Where Tehran? Okay, I see you to the bottom. Go ahead. Sorry.
So I was saying that government need to take a note because when it comes down to my job, the first thing they require you is to sit on the requirements that you must be Bahamian.
Uh-huh.
They're breaking their own law.
They
Right,
break it
so
all
now,
now.
so what you doing to me now? Because you give me permanent residency with the right to work. What you doing?
Discriminating.
Discriminating.
So what I'm
But-
gonna use on you?
That two-prong approach,
Yeah,
two-prong
Barry
test.
versus recruitment revolution and others, eh?
Yeah.
Yeah, so that's the first thing I'm gonna use on you. All right, any questions on the law relating to the recruitment process?
I have a quick question. Is there a
Okay.
limit on the weight requirements that a person may be asked to lift? Or does it depend on the industry?
Well, I think it will be relative to where you work in. So, if you work in the airport, that's a whole, they should have someone to help you as well as if you're working in the hospital because you have to move patients.
Mhm.
Right.
So as much, it just, you would put a minimum limit, but you wouldn't put a maximum. So must be able to move at least 25 to 50 pounds. So that means I can share the load with someone else. Eh? I don't really have to move 25 by myself. I may have someone to help me lift. Because it will be health and safety in the workplace. I shouldn't have
Yes.
someone working, lifting 50 pounds and they get hurt. Eh?
Right.
Right.
I should make sure that it's reasonable. So I only have that there in my advertisement because I want you to know you go help lift, but I'm sure I must ensure that someone is there to help you. Because moving patients is a part of your job, but you shouldn't be moving them by yourself, eh?
Yes.
Because you could be sued if they fall, and the hospital could be sued
If you hurt.
you're hurt trying to
Mhm.
move them as well. Okay,
Yes.
all right, so selection process.
The selection process may involve conducting background checks on the potential applicant and conducting interviews with shortlisted candidates. Employers should be fair and objective in both. Only information that is pertinent and relevant to the decided whether a potential employee is qualified and has the requisite skills, personal characteristics, and attributes that are necessary to successfully perform the job should be obtained and used in background checks and in conducting interviews. It is important for the employer to know his employee, not only as an integral part of the selection process, but also from a due diligence, compliance, and risk management perspective. Employers should take particular care in selecting new employees who have good character, integrity, strong personal and professional ethics, and technical competence to work within the organization. Any negligence in selecting suitable persons to work in the organization may result in exposure to various risks, example, reputational, legal, and financial, including customer service and goodwill. When conducting interviews, employers should set clear objectives and carefully structure the interview to obtain personal and professional information on the potential employee that will assist in a responsible and suitable hire. While interview questions may take the form of open-ended or closed-ended questions, employers should ensure that questions are asked in an interview are not biased, prejudicial, or discriminatory in any way. Additionally, employers should ensure the environment, setting, and nature of the interview are professional, within business hours, unless otherwise mutually agreed, and in accordance with company policy regarding equal opportunities, anti-sexual harassment, and professional conduct. Assessment tests may also be given to potential job applicants to determine the level of certain key competencies that are relevant to the position. Employers must ensure that these tests are relevant and appropriately designed to achieve this objective. Whether the tests are for verbal and numerical ability, computing skills, intelligence, or personality, it is important that they are standard or administered in a consistent manner, reliable. They test what they set out to do, and valid. What they measure is useful in predicting job performance. The appropriateness of the test is dependent upon the user's objective understanding of the test and the assessment of the results in relation to the job. Go on.
Give me 1 second, please. 1 second, please.
Okay.
Sorry about that. We can continue. I apologize.
Okay. Employee performance. It has been argued that one of the major causes of industrial unrest is the differential argument, where individual works or a group of workers believe that they are not being fairly rewarded for their work. A carefully designed job evaluation and performance system should be established fairly and objectively to not only alleviate potential conflicts in relation to rewarding performance, but also to create a strategic framework to measure and assess employee performance against established internal and external benchmarks.
Okay, so 1 second before we move on, the selection process. We didn't review that because I got caught off. 1 second, let me take this off here. So in the selection process, what do we do? Because we've already finished all of our recruitment process now. Yes?
Mhm.
What we doing in the selection process? We are now
Performing background checks with
yes, we checking on the employees
yeah.
who we shortlisted.
And
Before we make
interviews.
final decision, we're gonna make sure that their references check out, the police record is good. What else we gonna make sure?
We're gonna
They
check
give us-
their former employees.
Right, so they give us
Employers.
authorization to contact their former employers. And the employers can tell us a little bit more about them with a reference, and we just confirm that that's the reference they provided. What about their certificates, degrees, all that stuff? We're gonna make sure they have all those things, eh?
Yes.
Yes.
What about know the employee? You know, some persons, especially the hotels, I know they usually do they go and ask your neighbor about you, eh?
Yeah. They have,
Yeah.
yes.
Yeah. So they doing all of these things to find out. Now, can I go on social media and look at your stuff?
No.
Yes.
You
Yeah,
can't-
but they say
can't use it
you
against
can't
me.
use it,
You can't use it against me.
but you
then
can see
go
it.
but they doing that, eh?
They are.
I've heard that, yes, I've heard that, yes.
They doing it, but I guess they're not you're not informed that they're doing it. I think that's what they're doing most of the time. What else they doing? What we doing with the questions when we interview you? We doing what kind of question? Is it open or closed ended?
Open-ended,
Open-ended.
open-ended.
Or
Open
closed.
or
Or
closed,
closed.
and what should we ensure in asking these questions?
Because they're relevant to the job. Asked to be interviewed or not bias.
Okay, so I'm gonna ask you, you have any babies at home?
Mhm.
What that have to do with the job?
No, nothing.
Exactly.
Can I say that to you?
No,
What am I gonna say?
Are you available to work shifts? Are you available to work?
at night.
Is there anything restricting you from coming to work at 7 o'clock if we call you?
Right, that kind, yeah.
Stuff like that. If we have to work overtime until 9, are you available? So we're gonna ask those questions in order to find out if you have any babies at home, eh?
Right.
Mhm.
What else we gonna do? What we gonna ask you to see if you're gonna be able to work weekends?
Are you able to work flexible hours?
Okay, so if we have a project that is happening on a Saturday or Sunday, is there anything prohibiting you from coming in?
Right.
What else? We can do what? We can do tests?
Yeah, assessment tests.
Mhm.
Okay. And what else? What the tests all for?
Your skills,
That's
your
Level of
skill.
competency.
And
Yeah.
these tests must be appropriate, eh?
Yes,
Yes.
to what you're doing.
Okay, okay, let's go on to employee performance. Well, at least continue, sorry.
Okay. A fair assessment criteria for employee performance should be clearly established and communicated to employees throughout the organization so that they are aware of the company's expectations and requirements in the performance of their jobs. This is particularly important where the payments of performance bonuses and other benefits are attached to performance or evaluation systems within the organization. Failure to establish a clear and cohesive performance evaluation system or consistently provide employees with meaningful feedback regarding job performance may result in potential industrial or legal action for wrongful or unfair dismissal on certain grounds. It may sometimes be difficult to judge employees' performance, particularly where an employee's performance is measured more in qualitative terms, even in relation to performance-related pay.
Okay, so the performance, this is a major cause of industrial unrest because I may feel that I'm not being rewarded fairly for work. Now, the job evaluation should be established fairly and objectively, which alleviates potential conflict in relation to rewarding performance, but also creates a strategic framework to measure and assess employee performance against established internal and external benchmarks. So what should be, the assessment criteria should be established and clearly communicated to employees, and payment of performance bonuses. Now, you know, there's a big problem with this bonus business, and attached benefits. So when you fail to clearly establish the performance evaluation system, or if you're not consistent with the employees providing feedback on their job performance, this could cause a potential industrial unrest or legal action for wrongful or unfair dismissal on certain grounds. So what you think happens when you come with these assessments? You just assess Johnny, and are you assessing Jane? Johnny don't do half the work Jane doing, but Johnny gets the best assessment. And he's constantly being incentivized with bonuses, but you know, as much as you tell Johnny not to mention his bonus, he's still making sure Jane knows. So what you think gonna happen?
Claim of unfair treatment or
Discrimination.
discrimination.
Right, because what you doing, you clearly giving me no bonus every year, but Johnny getting bonus, and all he do is go for drinks with you most of the time. So it's a boys' club, eh? So you should be fair in your assessment criteria, and you should communicate to the employees what are the expectations and requirements for the performance of the job. And it certainly is important for payment of bonuses, because you may have some things attached to me getting bonuses. So if I reach these thresholds, I should be able to expect my performance bonus based on this performance evaluation system within the organization. So usually these things are related to pay. So they say, once you reach a certain mark, you have to get at least 70 or something to get a performance bonus. And if I am sure that I hit all the marks and I'm able to get at least 70, I should expect a bonus, yes? So some organizations have that within their structure, that you'd get performance bonuses based on your evaluation and the criteria that you meet. Okay, G. Smith, you said you couldn't hear anything. Can you hear us? G. Smith. Hello? Smith is no longer there. No? Okay. Okay, yes, it's cutting in and out. Okay. You can hear us a bit now then. Okay, any questions on employee performance? Okay, let's move on to appraisals.
You want me to continue or someone
Yes,
else?
please. Yeah,
Okay.
yes.
Yeah. Okay. Appraisals. Job appraisals are a system of evaluation used by organizations to employees' current performance and in some instances, his future potential within the organization. It can be used for manpower planning, succession planning, training, career development, promotion, and the payment of bonuses. Additionally, appraisals can be used to evaluate competencies needed or required to perform certain jobs. Overall, an appraisal is meant to measure employee good and poor performance levels. Appraisals allow individuals to receive information and feedback on their work-related performance and potential, recommendations on training and development, and motivation to achieve certain goals and objectives within the organization. Employers should ensure that the purpose and nature of the appraisal system is clear and properly communicated to employees. The appraisal system, if properly designed and established, should do the following. 1, provide the employee with feedback on his work. 2, provide employees with an opportunity to participate in decisions which may affect them. 3, allow salary, promotion, and training decisions as fair and transparent as possible. 4, provide the opportunity for career planning, training decisions, coaching, and mentoring. Appraisals may sometimes prove challenging despite the objectivity in their design due to the subjectivity involved in measuring an employee's performance and job behavior within the context of other influencing factors like organizational culture, power dynamics and politics, relational issues, the nature of the work and work environment, and personal attributes. Some of the common problems in completing appraisal reports may include the following. 1, the assessment of individuals is often based on personality rather than the results. 2, subjectivity and personal bias by the manager or supervisor. 3, the tendency of some managers or supervisors to assume that because an individual possesses some positive characteristics, they are entirely without fault. Example, the halo effect. 4, the most recent events and or problems tend to supersede a true and honest current assessment of the individual's behavior and performance. 5, the strictness or leniency of managers or supervisors in completing appraisal reports. 6, the tendency to rate an average employee unfavorably because of exceptional or top performers in the department or unit, the contrast effect. 7, inconsistency in conducting performance appraisals or giving timely feedback or follow-up on comments, training, and areas for personal or professional development. 8, administrative problems due to the amount of time required to complete appraisals. If the foregoing problems are not managed effectively, the employer may be exposed to potential grievances, industrial and legal actions if decisions are deemed by employees to be made unfairly or unreasonably, and particularly if they are denied payments of performance-related bonuses or terminated for competency or capability reasons. In addition to appraisals by a manager or supervisor, some organizations have an appraisal system of multiple appraisers, which may either include the employee's supervisor or manager and another senior manager, or an assessment by their supervisor or manager, and a self-assessment or an assessment by their subordinates and or peers. Whatever appraisal system the organization selects, care must be taken to ensure that the appraisal system is fair, transparent, and clearly communicated to employees so that they may properly measure their own performance within the context of the company's goals and objectives, and their personal and professional goals and objectives.
Okay, so the appraisal system is used to assess the employee's current performance and in some instances, his future potential within the organization. It is also used for manpower planning, succession planning, training, career development, promotion, and payment of bonuses. It is meant to measure the employee's good and poor performance levels. It allows the individuals to receive feedback on their work-related performance and potential, and can provide for the organization to recommend training and development. So this employment law class should be as a result of an assessment, appraisal, and they will say this can be used now for what purposes?
Professional
Us to
development.
train you more in this area, eh?
Yeah.
So based on the feedback they get, they can say, you know, perhaps this course will help us in developing our employee to be able to help us more in the human resources area by getting some background based on what they're offering in this course. We'll be able to send them, and this will help our organization, eh? So the appraisal system should be clear to the employees on what are they being assessed on, and how their performance will affect, how their performance is affected by this appraisal system. So it'll provide the employees with feedback on their work, the opportunity to participate in the decisions that affect them. It allows for salary, promotion, training decisions. The salary may not move because they'll say cost of living and all this, not as much as that increase. Profits are not there. But if they're having a good year, they may decide based on your appraisal, we may be able to bump you up some more. It can provide the opportunity for career planning, training decisions. So I'm directing you on the career path that you should go in order to help the organization. So I need someone to be well-versed in the employment law area. So I'm going to send out my people to now take this mantle up using this course to now assist me when I may have some issues in human resources. They'll be able to answer these questions more fluently. As much as the appraisals are set, they can be challenging because of, as much as they're supposed to be objective, they become what?
Objective.
Bias.
Subjective based on the person conducting the appraisal, because they now put other dynamics are now factored in. Personalities, politics, the culture of the organization, the nature of the work and the environment, and how our relationship works out. So it's based on personality more than anything, when it shouldn't be, eh?
Correct.
It's subject to the personal bias of the manager or supervisor, so we may not be getting along. And you use that to find all sorts of issues with my work all of a sudden. Then you may put someone in such a light that they did the greatest thing happening since sliced bread, and you
Halo
put them
effect.
as, yes, as this the best thing that ever happened to the organization. Again, recent events or problems, so all of the good I've done has been outweighed by one bad thing, yes?
Yeah.
So
Yes.
something just happened and now you forget all the good I've done. I made one error and I'm the worst employee the organization has ever seen. Then again, the strictness or leniency of the manager in completing the appraisal reports. Then you may contrast and compare me to someone else. So you can't compare me to, you should compare me based on my work and what I'm doing. Don't compare me based on what Tom is doing, because Tom may be an overachiever. And I may be average, but I'm still getting the work done. So don't compare me to another employee. You should base me on what work is being performed. So that's an issue there you may find. Again, it may be inconsistent that you don't conduct performance interviews as and when they should be done, and you're not given timely feedback on what you found was wrong. So I'm not aware that I should be working or improving on certain issues, and then all of a sudden it just blows right up because it's been festering for a while, but you've never addressed it because you didn't have time to do the proper appraisals, or you just didn't get back to me with something that you found was an issue. Then there's administrative problems. due to the amount of time required to complete the appraisals. If they're not managed, you will find that the employer may be exposed to grievances, industrial and legal actions if some decisions made are deemed to be unfair or unreasonable by the employee, in particular when it comes to that consideration where I don't have the money I thought I should be getting, or I'm terminated because I'm incompetent and you never addressed the situation that I was incompetent in what I was doing. So you may have layers of appraisal. So we have the supervisor may assess me, another senior management may accompany the supervisor or have to review the appraisal. And likewise, I know in some banks, your subordinate has to give you an appraisal, so that affects you as well. So as much as you putting nails in their coffin, they can also throw some back at you. So it is a two-way street. So as much as you may give me a bad appraisal, I'm in a position to respond. And you must ensure that the appraisal is always fair and transparent and clearly communicated to the employees. But of course, we have these faults that are going to take place, and there's no control over that human element playing into the appraisal system because we have subjectivity and not objectivity. It's not as if this person doesn't know you or anything. They're actually acting in their own stead, and they're not as objective as they should be. And so that's where you would find that you would have instances of grievances with the employees based on the appraisal system. Any other questions on this appraisal system? Any examples you may have of what may happen in the appraisal system in your organization that would now you can identify based on what has been said here?
It's a good opportunity to learn not what to do.
Right. So that's a good thing. So you can use these as pointers in now the appraisal and just bringing awareness to what the appraisal system, what the pitfalls are for the appraisal system. Okay, let's go to references. Who's gonna help us with that one? When we finish with references, we are going to skip all of the acts because what you're gonna do is read that on your own. And we'll just answer the questions, and we can probably just answer the questions on the app. But I think we should do a little review before we're done. Okay,
Yes.
so let's do references and then we'll do our wrap-up questions. Who will help us with references? Anyone?
I can take it.
Help us today. Thank you.
References. With regard to obtaining a job reference for a new employer and for a new, I guess that should read employee. An employer is under no legal obligation to obtain a reference for a potential new employee. However, it is recommended that the employer obtain at least one reference from a third party on behalf of the applicant and/or make the job offer conditional upon receipt of a satisfactory job reference. If an employer makes an offer of employment conditional on receipt of a satisfactory reference letter and fails to obtain such a letter, he may withdraw the job offer, even in the case where an employee has already commenced work. Oftentimes, the employer will stipulate this term in his letter of employment. It is the employer's decision as to whether a reference is satisfactory or not, and should make this distinction in their letter of offer to avoid any uncertainty as to what satisfactory or unsatisfactory means in relation to the job reference. This practice is critical because if the offer sent to an employee makes no mention of satisfactory reference or stipulates the receipt of such reference as a condition of employment, the employer will be in breach of the contract if it withdraws its offer to the employee after it receives an unsatisfactory reference. The employer may then have to pay the employee in lieu of notice or work out the terms of termination and/or notice. The employee whose offer is withdrawn upon the prospective employer's receipt of the unsatisfactory reference may also have a claim against such an employer if loss is suffered. Under common law, an employer who provides a reference for an employee must provide one that is true, accurate, and fair. Otherwise, he may be sued in tort for negligence, or rather negligent misstatement, if he fails to provide a truthful, accurate, and fair reference, and as a result, causes the prospective employer to suffer economic loss. This may occur in the instance where the former employer does not mention some act of fraud or dishonesty of which he was aware, and the employee goes on to commit fraud or other dishonesty at the new employer's place of business after being hired. The employee also has similar cause of action in tort, as the former employer has a duty of care to the employee regarding the preparation and issuance of a reference on his behalf. Spring versus Guardian Assurance, PLC. Even though the reference may be factually correct, it must not give the prospective employer an unfair or misleading impression of the potential candidate. Omissions do not generally impose a tortious liability on the former employer unless such omissions, again, give a misleading impression of the prospective employee because of the omission. Because of this premise, it may be good practice for former employers to decline providing even a standard reference for persons who may have been dismissed summarily for gross misconduct, fraud, dishonesty, etc., without mentioning the summary dismissal or its grounds.
Okay, so before I move on, an employer is under no legal obligation to obtain a reference for a potential new employee. So we should know that, eh? They don't have no legal obligation to get one. It is recommended that they do from a third party on behalf of the applicant, or make the job offer conditional on receipt of a satisfactory job reference. So I can ask you for a reference from your former employer. So I have to be clear on what is the satisfactory job reference I'm looking for. I'm looking for a reference, a satisfactory job, a reference from your last employer. Not the one before this one. I want to know for the last one, because that's the one who you just leave from. I want to make sure what I'm getting. Now, it's conditional on receipt of the satisfactory reference letter. So if you don't bring me the letter, or if you bring me a letter that's not satisfactory, what can I do?
Withdraw the offer.
I could withdraw, because that's the condition that I put on it. Notwithstanding you have already been working here for 2 weeks, you just get me the reference because you said the people were off the island, eh? So I gave you an opportunity to get it. You get it? No, this can't work. This way we part ways. And that should be clearly stated to avoid uncertainty as to what is satisfactory and unsatisfactory. Yes? So we know what satisfactory would be. What is unsatisfactory?
A bad one.
So what it could be, what I could say that's unsatisfactory.
You were insubordinate,
Fraud.
never come to work on time, was not responsible for the vehicles,
Stealing.
Now, what happens if I now have an unsatisfactory reference and you withdraw the offer?
If you've not made it clear in the offer that that was a condition of the employment, then
I may have a claim, right?
Yes.
Yes.
Because I suffer some loss. I want you to put me in the position I would have been had I not taken this job on.
Wow.
So the employer who provides a reference now, so now we pass looking for the reference, we looking to the former employer who provides a reference. What they must do, provided that is true, provide one that's true, accurate, and fair. Otherwise, he may be sued for negligent or a negligent misstatement if he fails to do so, right?
Yes.
Because what you will cause,
Economic loss,
To who?
the prospective employee.
Employer.
Employer. Because what
Sorry.
happens? What you may do? You may not mention that what?
They stole money from you,
Mm-hmm.
and then they go and do the same thing with their new employer, and he suffers a loss because of the negligence of you failing to advise, this is why, let this person go.
Okay, now what the problem we have in now, because now you were truthful in your reference to this potential prospective employer as the former employer. What the employee now has. The employee also has a similar action of authority,
Yes, you can be
Because-
sued
because, for what?
for presenting this
Um,
information.
On his behalf.
But it
right?
was truthful though. It was truthful.
It may be factually correct, but,
They suffered economic loss.
so what they say, even though it may be factually correct, it must not give the prospective employer an unfair or misleading impression of the potential candidate. What if I omit to say something?
It could be the same.
Because you may be misleading them, eh?
Yes.
So what is what is good practice?
Don't provide one.
Don't provide one.
Okay, but where they have been dismissed for what?
for cause.
Fraud or
If you-
dishonesty.
Right, so where you you can't provide and without mentioning the summary dismissal or its ground, right?
Right.
Right. Okay, let's continue on, because now we get interested.
I have a question.
Mhm.
If a potential employer contacts somebody who's been shortlisted
Mhm,
for reference,
mhm.
and if that relationship with the former employer didn't end on good terms, and the employer declines to provide any kind of a reference other than, yes, they worked here from this period to this period, could their refusal to provide any information also, like, it paints the employee now in a weird light, like the potential employer, the new employer is like, so why wouldn't you give me a reference? Can that be a disadvantage to the former employer to have not provided anything beyond the
Now, if I clearly state from you are employed, I don't provide references. So when you leave here, I clearly stated that that's on you now. If you go, you can advise your new or prospective employer that that's a stipulation that they provided in our previous in my previous employment. They don't provide references.
Mhm.
So
Okay.
you won't be able to get one from them because that was clearly stipulated. Now you can call them and confirm that, and they can confirm that they don't,
Okay.
because they're avoiding potential liability, eh?
Okay. That's interesting. That's interesting.
Yeah, because I don't have to provide one. I'm not getting in that. Let me stay out of that one. That's simple, eh? So I'll make sure to put that in as a part of our contract, that when you leave here, I don't provide references.
I don't think the small companies would have a problem with that. Maybe like these big corporate entities might have an issue with that,
Right.
because they
Because
would
I
have more to
can't-
lose.
Right, I don't want to give a good reference for you just to get rid of you, Kendra, because what happens in that instance? I may give you a good reference, and what happens? You already did something dishonest on my job,
Right.
and a new potential employer hires you based on that good reference, and you did the same thing,
They could
and
come
they
back at
find
you.
that out. So now what they could sue me for? Negligent, what?
Yes.
Yeah. Misstatement, eh?
Yes, because the former employer would have a duty of care to provide information that is truthful,
That is
accurate, and fair.
faithful, truthful and
Yes.
accurate, yes.
Mhm.
Yes. Okay.
Can we do that with landlords?
It is a
You
contract.
know, they can't wait to run off their mobile the last.
Wow, just wow.
They gotta wait to tell you, don't bring them in your house. They don't pay their rent. That time you find all kind of things wrong with their house and you leave it. But they would just drag you through the mud. They were a slumlord, but you move on. And then they now muddy the waters for you.
Why I asked that is because I don't know if you remember, we had an open house and our chairman made some comments in the media,
Mhm.
and they were talking about our arrest status.
Uh-huh.
And ironically, I was listening, and when I was like, if you look at the majority of our files, you see that these landlords were saying these people was paying their rents, but they probably just trying to get them out of their apartments. I don't know.
Simple as that. They
Yeah.
could wait.
All right, so that's why I said if we could sue them.
But I mean, you know, if you defame me, I have a recourse against you if you can prove that it's not accurate. So it's the same thing because that's negligent. What? That's a
Misstatement.
negligent misstatement.
Right. But in some cases that could be true.
Yeah. So then it can only be if it's proven, then you would be found guilty for that negligent misstatement. But if it's not true, then it goes away.
Right.
Okay, let's continue.
The employer should ensure that the most suitable person to comment and provide the reference is authorized to prepare, authorize, review, or issue the reference. The reference should also be prepared by the authorized person in accordance with the internal policies and procedures of the organization and upon proper receipt and review of all pertinent personnel and other information regarding the individual and his employment with the organization. Where there is an express or implied contractual term to provide a reference in the contract of employment or settlement agreements, an employer is legally obliged to provide such a reference. They may also dictate that the reference be written in a particular form or manner. In such cases, it is good practice for an employer to clearly mention that it may reserve the right to alter the reference as required or appropriate, or not to give a reference at all if there are facts which comes to its attention after the contract of employment or settlement agreement, which makes the reference untrue or inaccurate in whole or in part. Notwithstanding the fact that the provision of a reference.
So hold on, before we move on, what that reminds you of what we spoke about earlier? Remember the insurance contract?
Yes.
So that's an omission that will do what?
Cause them to deny the claim.
Yeah, so now likewise,
The employee could become, the new employer don't have to hire you.
right, based on
If it comes to the attention that the reference that it was untrue or inaccurate in whole or part.
yes. So we can go from there. So they could alter the reference as required or appropriate or not give a reference if there are facts which comes to his attention after the contract of employment or settlement agreement which make the reference untrue or inaccurate in whole or in part. Okay, go ahead.
Notwithstanding the fact that the provision of a reference letter by the employer may be an express term of a contract of employment or settlement agreement, it may still be considered an implied term in the absence of such an express term, if it is the employer's standard practice to provide a reference, or the nature of the employee's work requires that it is standard practice for a reference to be provided, particularly if it would be unreasonable for a new employer to hire the prospective employee without a reference.
So where it is the fact that it may be expressed as a part of the employment contract that they'll provide a reference letter. It may also be implied in the absence of the express term. If they didn't put it in there, it can be implied based on what standards of practice you have. It's a common practice that you provide references, or the nature of the work requires that it's standard practice for the reference to be provided, particularly if it would be unreasonable for the new employer to hire the employee without a reference. So unless you expressly state that you're not, it could be implied based on common practice or what has happened before, or based on the work and the potential prospective employment that I should get one. It could be implied that you have to provide one. Go ahead.
Under employment law, an employer may not refuse to provide a reference for discriminatory reasons or in retribution to a former employee who has made a claim of discrimination against it or blew the whistle under some whistleblowing policy, law, or regulation. Employers are encouraged not to make unwarranted or unfavorable comments about an employee's absence due to sickness, as that may constitute disability discrimination under law. Likewise, it must be fair, transparent, and consistent in its approach in providing references to all former employees in order to minimize exposure to potential legal action based on discrimination or victimization.
So you shouldn't put in there making a note that they have been constantly absent from work. You know, they have some mental or health challenges that Sue is a good employee. However, her health challenges have proven that she had to be absent from work. So that shouldn't be in there. Eh?
Correct.
Likewise, you can't refuse to provide a reference because you've taken out revenge on your employee for now telling the Securities Commission you were doing something wrong, or central bank. Yeah, that's what happened. They take the money out of the people's account, double dip on the same. You can't, because it was what? It's a law that I have to report these things unless they hold me accountable. Eh?
Right.
So you don't make any unwarranted or unfavorable comments about the sickness, absence and sickness, because you could be sued for discrimination under the disability law. So you must avoid and minimize exposure to potential legal action, taking these things into account. Go ahead.
Additionally, employers must be aware that any untrue statement, orally or in writing, that damages the reputation of an employee in the eyes of right-thinking individuals may amount to defamation, example, slander or libel, particularly if the person giving the reference knows or has reason to believe the statement is untrue and or has failed to check or verify the truth or accuracy of the statement.
So what did we talk about just now with those landlords?
Misrepresentation of the truth.
Yes, so you slandering my name. And you know, in the eyes of right-thinking individuals, they may consider that to be true based on how you put that story together. So what I want to do?
Sue you for slander.
Right, you use something else. So you have to make sure that the statement you're making is true or accurate in order for you to avoid being found liable. Eh?
But you also mentioned that the former employer cannot mention that a person was out sick because of illness, but wouldn't that also be unfair to the new employer to keep that information out of your reference?
Now, wouldn't that be incumbent on the employee to advise of that? That's not for me as the employer to say. Because then I'm not, you know, we have what we have, and what laws would cover that? Where you can't do that.
Disability discrimination.
Right. So what we have, what was one of our laws? Would we have to look at? They have it in there, and I think it's in the Employment Act, where you can't
discriminate against
someone for illness.
Right.
So the fact that I am unfit may disqualify me, yes? Because basically I would put in what am I gonna cover to ensure I don't get persons who are not able to function properly in the environment. I'm gonna fix my what?
Your application, I guess.
No, what am I gonna fix as the employer so I don't get these kind of people?
Oh,
My
must be
advertisement.
Yeah, so what I'm gonna fix in there, right?
physically fit.
Oh, we can't say that, we can't say that. What we gonna say?
Able to work 40 hours a week.
This is a highly what? Energized environment. What else? We're gonna put some things in there that shows you if you're not up to the task.
Able to lift at least 50 pounds.
A lot
Right.
of specifics.
Right, and so what happens now, if I find that you are, what? You can't do it, what happens?
Yes, I don't hire you. Yes.
No, what I'm gonna say, if I hire you and find out later you were sick, what happened?
You were dishonest in your you were
In your
not
application.
in your application or something.
No, well, I wasn't dishonest, that wasn't, I could do these, I thought I could do these things, but now I find out what you have a duty to do what? Perform your work
Fairly and honestly.
competently, eh?
Yes.
Yeah.
You should be
Miss-
competent. You
Ms.
you're not-
Dorset,
Huh.
I've seen, certain employers, they would send over a reference, like questionnaire or form for potential hires. And they would ask you to comment on the employees' attendance and their
Uh-huh.
punctuality. So what are you, if they,
Now, they can't tell you how you run your organization, though, eh?
I know, but I mean, in most cases, the former employee would have signed off that they have authorized you to release the information. You would see, they would send over the authorization form with the employee's signature. I've seen that several times.
Yeah, but
They okay you to comment on the attendance and the punctuality and
yeah,
and
but you see,
performance.
they could say anything until it affects them, then they, all of a sudden they remember their rights, eh? You see, so you know, they say, yeah, go ahead, release the information. That's fine that they ask for that. But you already say, I'm not leaving myself open to foolishness. I finished with you.
Okay.
Yes, I already
So-
said I'm not providing this, so let your people know, don't contact me.
Okay.
Simple
so
as that, eh?
You should stay clear of that then.
Right, I mean, unless you want to be involved in potential litigation.
No.
But
you
it
would
will
want
still be
to-
unfair to your new employer because you basically coming in under disguise. You're not being honest.
Yeah, but I don't know that the new employer could ask those questions. That seems to be discriminatory, eh?
Yes.
Mm.
So that may be outside of the purview of what they should be doing as well. And then you as the former employer should say that's not, I won't be, that's not something we disclose from our what we do. We just provide you with the work, all of those other things.
The
That's not
basics.
for me, right?
Mhm.
That's not for me to say.
Can you also indicate if you have to write a, I call it confirmation of employment, whether or not the relationship ended on a voluntary or involuntary basis, or is that discriminatory?
So I can just say, she used to work here. And
From-
if I going to say she was summarily dismissed, what I have to say?
Why?
Yeah.
No,
'cause
I
they
don't-
say they-
You'd have to
I don't know.
disclose that.
Do you have to disclose the reason why, or just the fact that it was a summary dismissal or of involuntary dismissal? Is it another way of putting it? Why would you have to disclose the reasons behind it? That's no one's business except between those two members.
Right, but if you
party to the
summarily
contract.
dismiss someone and you don't mention it, what happens?
It looks suspicious.
Right, no, if you summarily dismiss them and you don't mention what was the reason for the summary dismissal, you leave a lot to be assumed there, eh?
Will you
Correct,
open the
yes.
door then for the employee and the potential, the employee and the potential employer to have a discussion?
Because
You
now you
stay out.
leave some misleading impressions when you just say they were summarily dismissed without mentioning the summary dismissal or its grounds.
Okay, and is that worse than not mentioning at all that they were summarily dismissed?
Well, I mean, if they're asking for a reference, yeah,
It wouldn't be true. It wouldn't be
It-
true.
Exactly.
it must not give a misleading impression.
But that's not misleading if they were summarily dismissed for some breach of agreement.
So then you would say they were summarily dismissed, and you should mention the reasoning.
Yes,
Mm.
because it doesn't
Wait.
necessarily mean it will be a disadvantage to the employee either.
Right, so the employee may say, I was dismissed because of so-and-so or such and such, right?
Mm-hmm. Or I was asked them off the floor and that was not within my, they might be able to defend that.
Right, because you can't omit certain things because your omission could lead to what?
The person
The
not being
potential-
hired.
The prospective employer hiring someone and you left out an important factor. But if you now see, what we say, first of all, you're gonna ensure for this reference.
That it's going to be truthful, accurate, and fair.
And what we're gonna have what we're gonna have in order for me to provide you with a reference when you leave here. We'll put that as a part of the contract.
To say that we won't provide one or something?
We'll put that in that we provide or we don't provide, yes?
Yes.
Yeah.
And then what we gonna do?
And let's say we determine that we've made the statement, we will provide a reference.
Mhm.
And in order to be truthful and fair and honest in that reference that we're asked for, we disclose that the relationship with this former employee ended on as a result of a summary dismissal.
Right, okay. And
I
what-
don't see where the former employer needs to divulge anything more than that.
So if you say summary dismissal, you would say what the grounds were. It's only certain grounds, It's only gross misconduct for dishonesty, one of them,
Right. They
Right,
could
so
get that out of the act.
She's saying not to disclose whichever one it was.
Exactly.
Yeah, but you have to say it,
Once you
No.
do the summary, yeah.
Yeah, once you put that there, you should say what it is.
So you would recommend then just not saying anything beyond, yes, they worked here for this period in this capacity and with this compensation. End of story.
I don't know if you even could disclose compensation,
Well, even if you take that out, just yes, they did work here in this capacity for this
They
period of
worked
time.
here, they worked here, that's it. So is that satisfactory as a job reference?
No.
Mm,
Okay, so then I don't need to hire you.
So Ms. Dorset, what about permission? I mean, does an employee, a potential applicant need to give you permission to do a background check?
Yes, yes, if you coming in, you said, well, based on this, they usually disclose that to you upfront,
Yes.
They usually tell you that upfront that they're gonna have to do a background check. Because you can't check into me just so,
Well, you could verify the contents of the resume. You're presenting that as your truth. We want to trust but verify.
So how would you get this information on me if I didn't give you authorization?
By
but
your submitting your
see it by-
resume.
you can see it by my resume that I would have worked
Yes.
these places, but that doesn't
Right,
necessarily, you may not have, I might not have outright given you permission to call my employers. And then employers nowadays, if someone calls and say they want to do a background check on individuals, not all the time they have written consent. They just go ahead and, give it verbally.
so
Well, they-
are you supposed to give out my information?
No, I don't think
No.
so, no.
No.
No, so you
No.
can't go on no background check without me getting authorization. You can't go to the bank and find out about my account as another banker without me giving, that's what's supposed to happen.
So, Ms. Dorset, if the potential hire lists references because
Mhm.
your form requires that they give you 3 references. Isn't
Right.
that in itself authorization to
Authorization.
contact them to?
But it's authorization to contact those 3 references.
Those,
Right.
don't contact Joanne who
We-
was working next to me because
Ex-
I didn't
we didn't get
give
along.
Joanne no authorization to talk about me to you.
Exactly. So of
Yes.
course, we know that we put the persons who we know gonna say something good about us or
Good
not
about us.
thing about us. So if I go outside of that, I may put my supervisor who I know I had a good relationship with, but I may
Mhm.
the department manager who can tell you everything. So if I go and contact the department manager, I mean, is that an issue? Because I didn't list that person.
So how
But
you get to the department manager? That ain't my reference.
But Miss Dorset, now you know people are only going to list references who they know.
why
are
would
gonna
I
give
list
them-
someone who I didn't have a good
Exactly.
Department
relationship with?
manager and I had some personal issues. She was personal with me. We knew each other, or we had former acquaintances that we crossed over. And she always had issue. That's why I leave this place in the first instance.
So,
I
Ms.
don't want
Dorset, the
nothing to do with
practice
her.
of getting what we call backdoor references, where you go to a reference that was given by the applicant.
So
And in the,
usually but you don't want a reference from their colleague. You would want it from someone in authority like human resources, eh? So you don't want it from, you want it from the human resources department. That's where you would be looking for it from, not from their immediate supervisor, because that's a bit subjective, eh?
but again, if you want to find out what kind of employee this
The
was
true
to work with,
person,
if
yes.
if they didn't work in HR could only confirm the facts. Yes, they
But
But
worked
so
there for
that
this
means
period of
there's a
time. So,
breakdown in the organization, because HR should know them well. Yes, hold
I
on
mean,
one second.
HR could speak to them not having had any disciplinary actions on file or anything like that, but whether they showed up, like all in to work, that's really something the supervisor would be able to speak to.
Yeah, but the supervisor was the reason the people ain't working there no more. Supervisor take their role too personally, so we don't want nothing to do with them.
They
I
might just
already
know the true
report them
you.
to HR. That's why I'm leaving.
Exactly.
That's on my exit interview. You need to move that supervisor because she got problems.
But I might know the true you as your supervisor.
You better let the true human resources know that, not you. I don't want to hear from you because you're too subjective, and let someone else objective take of you. Because human resources are not working with me day to day, and so they may be able to have an objective view unless them and the supervisor go to lunch every day and they talking about everyone anyhow. Yes?
So it sounds almost like as an employee, if a potential you're being shortlisted and interviewed, that you are honest and upfront. I didn't have a great relationship with my previous supervisor for these reasons.
Yes, I would say that. I mean, nothing wrong with that. And I mean, it's best because then you may have that, you may be protecting yourself because you may be sitting before another one of those supervisors. So you letting them know from the break, I'm not going to tolerate certain things. And that's why I left. And so if that potential person is the same, you saving yourself from going through another job where you have to leave.
Yeah. But
So
that's
it's easy.
interesting because I've done what we call backdoor references, where I go to the person who was authorized for me to contact and I say, is there anyone else in your organization who can speak to the character of this person or who has worked with them? And it's interesting to hear now that may not be legal.
No, I not that it's not legal, but I don't think that's where you should get it from. I think you should get it from human resources because that's who should have the file.
Right.
And not, I shouldn't get it from your supervisor. I should get it from human resources.
Interesting.
Ms.
Yeah. I don't-
Dorset.
Huh?
Ms. Dorset,
Yes.
I've noticed in the newspaper, sometimes you see where there's a notice saying this person is no longer authorized to act on behalf of XYZ.
Right. So what you think in the eyes of right thinking individuals? What you saying?
He did something dishonest.
Yes.
Right.
you
That's
see?
what it tells me. That's
I may have
almost
an issue.
defamatory.
I should have an issue with that. Don't put my face out there because when you hire me, that's not how you hired me. I have a problem with that.
But I find too that the person is not always dishonest. It's just to say that the person is no longer working. Right.
Right,
No,
so
and
if you can't put more, don't put it there. Because
it
you
it
leave it
really makes the
open.
person look like they did something wrong.
Right,
does,
so
it
they
does.
need to discourage that practice, or someone needs to take an issue with it to stop them from doing that.
Mhm. So the better process for an employer who has, let's say they have a salesperson and they want to let their clients know this person is no longer in sales for my business. There should be direct contact with the clients to say,
Simply, that's all. I mean, just simply let them know that.
yeah.
But why are you publishing that for the world to see? What's going on?
Yeah.
You trying to say I'm a thief?
Wow.
Now I leave, but you know, you may be trying to protect yourself to say, you know, something. She may go there and try to solicit my customers. Let me let them know she don't work for me no more.
But that is not what the average person would think. The first thing I thought when I started seeing them was that this person was dismissed for dishonest practices. And then I met two persons who that had happened to. And in speaking with them, it didn't seem like that was the situation. Not that we were discussing it, but in speaking with them on a general level, it didn't seem like that was it. It was like just like the business saying, look, they no longer work for me.
So what do we say? What we say that is?
Misleading misrepresentations.
So what we say in the eyes of right-thinking individuals, what you would
That's what it looked like to me.
Yes, right. That's what I'm saying. So until the people address that, they will continue to do that.
Wow.
Okay.
All right. Additionally, employers must be aware that any untrue statement, orally or in writing, that damages the reputation of an employee I read that already, didn't I?
Me don't mind.
Okay, in the eyes of right-thinking individuals may amount to defamation, example, slander, or libel, particularly if the person giving the reference knows or has reason to believe the statement is untrue and or has failed to check or verify the truth or accuracy of the statement. A defamatory statement may also be made by a person who is unauthorized to give a reference, but does so untruthfully, even if the person receiving the defamatory statement has no interest in receiving it. If the person providing the reference makes an untrue statement maliciously, knowing it to be untrue or reckless or negligent in doing so, the employee may bring a claim for malicious falsehood against the employer, again, vicarious liability. Due to the potential legal risk in providing references, some of which are mentioned above, it is now common and in some instances best practice for employers to provide references which simply mention the employee's position, dates of employment, and possibly his salary. However, the employer must be careful to make it plainly clear in the reference that it is its policy to give such a short generic reference in order to avoid any potential claim by the employee that providing this type of reference is biased or discriminatory towards him. Notwithstanding the aforementioned policy, the employer still has the option not to provide a reference for persons that have been summarily dismissed on certain grounds. It is interesting to note that in the United Kingdom, employers who are regulated in the financial services industry are required to, under the provisions of the Financial Services and Markets Act 2000, to provide more detailed information about employees when providing references to any other regulated employer, particularly those employees performing certain functions as prescribed by the Act. In light of the foregoing circumstances regarding references, it is good practice for employers, where they can, to include a disclaimer of liability in relation to any negligent misstatement. The insertion of a disclaimer may be effective in avoiding or rather preventing a claim by the prospective employer for statements. You want me to continue?
Yeah, sorry, I didn't realize I was on mute.
Okay, sorry. The insertion of a disclaimer may be effective in avoiding or rather preventing a claim by the prospective employer for statements made in the reference which were made by the employer to the best of their knowledge, albeit negligently. However, it must be noted that such a disclaimer would not be effective in preventing a claim from an employee unless he has agreed in advance in a contract of employment or settlement agreement for a reference to be provided on his behalf
So
with
we have
such a
that,
disclaimer.
so we have that wrap up right there in that little one little thing there. eh?
Mhm.
We could put a little disclaimer in there, provided that what we have done,
Provided that what?
what, provided that what happened initially.
That we have put it in the contract or it's included in your employee handbook on
So,
the
right,
policy
so
of the
unless
company.
you had that as a part of the contract of employment or the settlement agreement, that a reference be provided with a with that disclaimer in there as well. So you have to make sure that that's a part of it. So as
Yes.
much as I'm gonna provide you a reference, we're gonna include a disclaimer so that we won't have any liability actions against us for negligent misstatements. So I protect myself from the prospective employer as well as the former employee, yes?
Mhm.
Yes,
So
and
that's,
your corporate attorney will have that drafted appropriately.
yes, so we have a catch-all right there. Let's close that door and don't worry about that anymore, eh?
Yes.
Okay, so the Data Protection Act is good for you to read because it then explains to you about your protection of your data and all of that stuff, but I think it's good reading for you to, it's just on the act. So we won't have to go through it more or less because we want to do our little quick review. But read it for me, please, just to make sure you get what they're saying, okay?
Yes.
That's fine?
Yes.
Okay, so let's do our questions. Number one, define recruitment. What page we'll find that on?
70.
70, page 70. And what is recruitment?
Development.
Recruitment is the practice of analyzing a job, outlining the characteristics, competencies, and capabilities that the organization seeks in a potential candidate.
Okay. Number two, define selection, where we'll find that.
Page 70.
Okay, what is selection?
Selection is defined as assessment of candidates in order to choose the most suitable candidate for the position offered.
Okay. Explain the recruitment process, where we'll find that answer.
On page 70
70.
and
True.
yeah, and 70 to 72.
Yes, to 72. And just give me the first 4 steps.
The development of a manpower plan,
Mm-hmm.
an analysis,
Job analysis.
a job
Mhm.
description,
Mm-hmm.
and a personnel, sorry.
Specification at the end of the recruitment process, what are we going to have?
Selection.
Review of interview.
The review of the interview results and an examination of.
The candidates, their capabilities, etc.
Excellent. What are some of the objectives of a properly designed appraisal system? Where we'll find out?
On page 76.
77.
76. Uh-huh. 76. Where we
77.
find that?
77.
Excellent. Okay, what is it?
Provide employees with feedback on his work.
Mm-hmm.
Provide employees with an opportunity to participate in decisions. Allow promotion and training decisions as fair and transparent as possible. And provide opportunity for training, decisions, career planning, mentoring, and coaching.
Excellent. What are some of the problems experienced in writing appraisals? Where we'll find that answer?
77 as well.
77.
And what may be, give me 2 problems we may experience?
Personality rather than results.
Uh-huh.
Bias.
Administrative problems due to time required to complete them.
Okay, good stuff.
And personal biases
By the,
by the
supervisor, or the
Appraiser,
person
yeah.
doing the
Yeah.
appraisal.
Excellent. What are some of the best practices in relation to providing references for former employees to prospective employers? Where we'll
Don't.
find that answer.
The best practice is not to do any.
Don't do it.
Don't do it.
Do it.
Don't do it. Or put in a disclaimer.
So that's some best practices.
Yeah, don't do it.
Okay. So where we'll find this.
78 to 81.
78 to 81, we find some best practices there.
Oh, the best practices was on 81.
81, what is it?
It's a good practice for employers where they can to include a disclaimer of liability in relation to any negligent misstatements.
Uh-huh. And
That's it.
in order to include that, how I get that included?
In the
When you,
contract
in the contract,
or in
and
your
sorry, the
employee
initial
handbook.
contract, the initial employment contract.
We're gonna say that in providing reference, we will include,
A disclaimer.
yes, yes.
Disclaimer of liability.
Explain what should be done if a request is made for a reference for an employee who has been summarily dismissed for gross conduct from your organization.
To provide the employee's position, dates of employment, possibly the salary, and make reference that it is a policy to give only that information.
Okay, because what they say about that?
You can face a slander or libel suit from the employee, the former employee.
So on page 79, they tell us it's good practice for,
Option not to provide it.
right? It's good
Option not to
practice for
provide.
former
Got you,
employees to
okay.
decline providing even a standard reference for persons who have been dismissed summarily for gross misconduct, for dishonesty, etc., without mentioning the summary grounds or its dismissal. So don't even to provide one, decline providing one.
Mhm.
Got that?
Yep.
Yes.
What do the data protection law requires in the terms of reference for employees? You think you could find that quick? We didn't read it yet, but you think you y'all read the chapter first or no? Look on page 81 at the bottom.
Right. To ensure that the information obtained is obtained by fair and lawful means.
Right, in relation to references though,
Oh,
right to the bottom.
The provisions of Data Protection Act prohibit an employer from giving reasons for an employee's absence to sickness to a prospective employer.
Or is it additionally, it should be noted that an employee is allowed to request,
And be shown,
be shown the reference
Of a previous
of
employer.
a previous employer.
if he,
So desires under certain conditions, guidance on best practices.
so that's what the Data Protection Act provides.
Yes.
Prohibits the employer from giving reasons for an employee's absence due to sickness to a prospective employer. So that's prohibited.
Okay,
And the employee is allowed to request and be shown the reference of a previous employer in his personnel file if he desires under certain conditions or guidance on best practices.
that's why it's best not to do it at all.
Because they want to see that so they could go, you sending me home for this? Okay, let me see that. What are the implications of the Data Protection Act on employee privacy rights?
Also on page 81, I think.
83.
What it says.
The individual has the right to access any personal data kept on him.
This is now data protection and employee privacy rights. What they say?
It should be used fairly and lawfully. It should be kept up to date and
So
kept
what were you reading from? 83, right?
page 83, yeah.
Okay, go ahead.
It should be kept for specified purposes. It should be relevant, not excessive in relation to the purpose for which it's kept. It should not be discussed in a manner that is inconsistent to the purpose for which it is kept. Shouldn't be kept longer than the necessary, except for where the data is historical. Data should be kept securely from unauthorized access, alteration, or disclosure, or accidental loss.
So that's for their privacy, eh?
Mhm.
And these are only overridden in the case of section 13, eh? Which is at the bottom of 83 and the beginning of 84.
Yeah, at the
Under section
National
13,
security. Yeah.
13 of the Data Protection
section
Act.
A.
Okay, what are some of the key provisions of the Computer Misuse Act?
Unauthorized access.
There are 6 offenses, eh?
Yeah,
That's
The
the key
offenses.
provision. What are the offenses? Where we'll find them?
on page 85.
Page 85.
And they are,
Unauthorized access to computer material, access with the intent to commit or facilitate the commission of an offense, unauthorized modification of computer material, unauthorized use or interception of computer service, unauthorized obstruction of use of computer, and unauthorized disclosure of access codes.
excellent.
That's interesting.
So just read over those provisions, and then we can, that will cover the rest of what we have to do there.
Okay. Is
Now,
there any quick question? Is there any guidelines on how long employee information should be kept by HR?
I am not sure, but I know the banking system has there's a limitation, eh? Isn't there a limitation on information? When to get rid of information?
I thought it was like 6 or 7 years.
That's what I thought, 6 or 7 years.
I'm trying to remember. I think it's 7 for the bank. They can archive it. We have it somewhere where we have it.
Somebody's saying it's 7 years.
Someplace I'll look whilst we doing the 7. Okay, good. It's 7 years. So I think that's the same thing for keeping information on the individuals, eh?
Mm-hmm.
But we can always just double check it.
Okay.
Okay, so now for our exam,
Yes.
what we're gonna have is true or false. It's not any labor intensive exam, okay? Probably about 20 to 25 questions because there's only 2 spots and you're done. And so we may ask questions on the Bahamian court structure, the bill becoming an act. We may ask some question on the industrial tribunal, its processes, composition powers, etc. We should look at how we would deal with trade disputes, how it's dealt with through the industrial tribunal. We should know about the contract, its elements, etc. What are some remedies for breaches? We should know the difference between an employee and the independent contractor, what is their contract? You all have the book, the labor law and the Bahamas book? Did you get it?
I got mine.
Okay,
I will get mine shortly.
yeah, it will help you too, because it really breaks it down good for you. So we should know whether the employee, what type of contract they're under. Is there a contract or the independent contractor? How will we know the difference in their contract? Is it a contract to offer for a service based on the position? Is it an employee or an independent contractor? We know the employment statuses. We should know that. We should know the duties of the employer to the employee, the rights of the employee, and the rights and the duties of the employer to employee to employer. We know about the tortious liability for the employer, the relationship between employer and employee and the tortious. So what we talking about when we talk about that?
The
tortious.
vicarious.
Yes, yes. We should know the standard terms and conditions that may be found in the contract of employment. And know the difference between the description, the job description, and the job specification. Job analysis at least. What's the difference? Is the employer under any obligation to provide a reference for a new employer in a potential employee? What about discrimination in advertisements? Do I have any right? Can you, for advertisements that seem to be discriminatory? What does the Data Protection Act say about references for employees? What is the purpose of the appraisal system? What about the employer contract? What is the relationship? As a third party, can I enter into that contract to sue for something that's not been done?
Nope.
We know the sources of law. And what section of the Employment Act deals with standard terms and conditions of the employment?
What was that, Ms. Dawson, the last one?
What section of the Employment Act deals with the standard terms of the employment? How does that work out? If I don't if I don't have any standard terms and conditions, what comes into play if I don't have? What section comes into play?
Okay,
Of the Employment Act?
okay.
You all know?
7-7.
Section of the Employment Act? Tell me. Somebody have to know.
Part 2?
What section?
Is that part 5 or part 2?
Section 5, yes.
Okay,
Section 5, 1,
okay.
that's on page 50.
Yeah, section 5 one. Mhm.
And of course, we know what offers and what acceptances remember any of the presidents of the Court of Appeal Industrial Tribunal? Do you remember how the Industrial Tribunal is composed?
President and 2 vice presidents.
Awesome stuff. How are they appointed?
By the Governor General.
Okay, man, you all didn't finish this exam.
And I think he speaks with, I can't remember who the other person is he collaborates with. Was it somebody from the
Advice
judiciary?
officer. They
Yeah,
still have-
advice
Yes,
yes,
okay.
Yeah, we finished with this exam. You all are on to the next part.
Wow.
Okay. All right, so once we look over that, this exam is done.
And this
We
exam is
have
when?
Short answers.
When?
That's what we're gonna check, so you'll get an email today.
Thank you.
You'll get all the questions on how it's gonna be administered, the time frame, and when. You'll just
Okay.
have short answers, true or false, and probably 1 or 2 multiple choices, only 25 questions. You don't have no long story to give. So fill in the blanks. True or false, multiple choices, isn't that easy?
Not always.
And you got a guide, my lord, this must be just a slam dunk. The next part may be a little bit more challenging.
Okay.
Ms. Dorset, thank you so much for your guidance and walking us through this. I almost feel ready, almost.
Yes, you're ready, I tell you. You all are very ready. You all have been engaged. I think you all understand this fully.
Thank you. You have confidence in us.
Yes,
I
you all
appreciate
are
the
very
confidence.
engaged. So and you answer questions, so you did well.
Thank you.
All right. Thank you. It was a nice class. I appreciate your.
Yes, it
engagement.
was.
Yes,
Yeah.
thank you.
Thank
All
you so
right,
much,
so
Ms.
do
Dorset.
well,
Thank you.
and y'all make me proud.
Thank you. We will try our best.
Okay, nice meeting everyone.
All
Yes,
right,
ma'am.
take care.
I have some names now and contacts when I need some help, eh?
Yes, ma'am.
Yes, ma'am.
All right, take
Indeed,
care.
indeed. All right, you too.
All right, do well.
Good
Okay,
day,
thank
everyone.
you. Good day.
Bye.